Hi everybody, I hope you're doing well. Today we are here again to learn about the tort of trespass. Now the tort of trespass can take the following three shapes and forms. It can be the tort of trespass to land, trespass to persons, trespass to goods, or what we sometimes call trespass to chattels. We're going to learn about each and every one of them individually, and by the end of this class or this online lecture, I hope you will be able to tell the torts apart. Let's begin. Generally, talking about trespass, we're talking about the following four elements. So every time we talk about any type of trespass, we're talking about the element of intent. The first element of intention, the person must have trespassed intentionally, and the second element must be direct interference. The person who is complaining the person who is complaining in the tort of trespass must have been directly interfered with. That means if I'm complaining about trespass to my land must have been directly interfered with and not my neighbor's land. Thirdly, we're talking about the injury the injury was inflicted on the plaintiff or the complainant. So when I complain about a tort of trespass, the injury must have been on me, myself. And lastly, there must have been no lawful jurisdiction or justification. The person did not have any legal right to interfere with my property. Let's go very quickly to trespass to land. This occurs where my land is wrongfully interfered with. For example, it can take the following forms. If somebody enters in my land when I have not authorized them to, for example, walking through my land or putting, if not necessarily land, like in that way, if I own an apartment and you put your finger or your hands through my window, you're trespassing over my land. Secondly, trespass can take the form of remaining on my land. Even if I have allowed you to access my land for 30 minutes and 30 minutes have expired and you're still in my land and you keep being there, you're trespassing to my land. Next will be placing things on my land. If we had a neighbor who used to throw rats on another neighbor's property, that is trespass. Be warned that is trespass. So it is different from nuisance. For example, when we talk about somebody throwing a rat into your compound, it is different from nuisance in that the rat does not affect how you enjoy the property. It just disturbs you. Yeah. So, and nuisance talks about you can no longer enjoy the property because I'm making a lot of noise or I am having water in my land. But this is just trespass because once or twice I throw a rat in your compound. That is completely different because you can continue living in that compound as usual. But nuisance has more to do with, can you continue enjoying your presence in that compound? Look at the case of Rylance versus Fletcher. You can tell from there Mr. Fletcher could not continue Mr. Rylance, could not continue enjoying his stay in his land because the neighbor was causing a nuisance. Yeah, so you should be able to tell these two apart, the tort of nuisance and the tort of trespass. Now, trespass to land is you can sue for trespass to land without showing any injury. For you to sue for nuisance, we talk about the elements of nuisance are the thing. You harbor the thing in your land. That thing could probably escape, and it escapes and it causes mischief on the other person's land. And injury must be an element in the tort of nuisance. But in the tort of trespass to land, you can sue somebody for trespassing over your land without showing any injury. That means you will not need to show the court that you have been injured for you to sue for a tort of trespass. Now, each time somebody trespasses your land, for example, he throws a rat today and you sue them today, and the court is still listening to that case, then he throws a rat tomorrow, you can sue again afresh. And every time the court will allow you to do what we call continuing trespass. If a person repeats trespassing on your land, each trespass is a different case. The court allows for a fresh lawsuit for every time the trespass is repeated. Unlike in nuisance, if I sued you for the water last week or last year or last month, I can't sue you again another time. So that I hope you note that one. Defenses. How can you defend yourself if someone ever said you have trespassed against your land? The first defense that you use is prescription. You can tell the court that you acquired the land by prescription. What do I mean by prescription? For example, the previous owner of the land would allow us to herd our cows or our sheep or graze our cows there. So you can plead and tell the court, okay, fine, it's his land, but in the past we were allowed to graze our land in that land, our cows in that land. Secondly, you can talk about necessity. It was really necessary for me to trespass that person's land. For example, you were trying to access emergency medical services, and you without authority passed through someone's shamba. You can always plead and say it was really necessary. Number 3, you can talk about I had statutory authority, which we have talked about previously in class. Statutory authority is where the law gives you authority to do the act of the act that would amount to trespassing somebody's land. For example, a broker who is trying to sell somebody's shamba can from time to time just go into the land, keep checking for any developments, so that the broker would know, before I sell this land, it has the following buildings, it has a borehole, so that while they're negotiating the price, they are aware of the things that are fixed on the land. Lastly, you can plead and tell the court, I entered into the land, but I had license. What is a license? For example, if I own a piece of shamba and then I allow people to rent the shamba, if the person enters into my land after they have stopped being my tenants, they can say, but we had a license before. But you be careful, the defense of license only applies if the license is still valid. I can give you a license to access my land because you're my tenant, yeah, but as soon as we finish, I'm looking for that word, as soon as we conclude on our tenancy agreement and you're no longer my tenant, I'm no longer your landlord, your license has expired. So if you had a license to enter the land, for example, say you're a tenant, then yes, you can use it as a defense, but be careful, the license need not to have expired. What happens then if you are the complainant? What are the remedies that the court has for you? Damages. We have talked about damages in class. The court will assess to what extent is your value on that land, how injured were you, and the court will give you a compensation. Ejection. Secondly, ejection, where a person on that land was entitled, where the person who trespassed on that land has lived there for some time, the court can give something that we call an eviction order. An eviction order is an order that tells the person in the next 21 days you're required to leave that land, or you will be arrested, something like that, or an arrest warrant will be issued against you. The third way the third remedy you can obtain from the court is an injunction. You can obtain an injunction from court. The court will, I don't know if I have mentioned this before in class. An injunction is a court order issued to tell the person, we are telling you to stop. In fact, it comes in the following words: you are commanded by the court of if it's a high court, but you are commanded by the high court to cease living on that property. An injunction, before the court grants you an injunction, you have to fulfill the three conditions set out in the case of Giela versus Casman Brown, where the court said before an injunction is given to any person, they must prove that, number one, they have a prima facie case. That means they have a first, on the look of it, there's a case, an actionable case. And number two, you must have The case must be capable of succeeding. You have a need that needs to be sorted out immediately. And thirdly, you have to prove to the court that if the court does not give you an injunction, you're going to suffer irreparable harm. So when you go to court and tell court, this person is trespassing over against my property, I need an injunction from you because, number one, this is my property and they're constantly passing through my property. I can no longer possess my property the way I normally do. And to fulfill the second requirement, your case can be actionable. You tell the court, he has never been my licensee, he has never been my tenant. And thirdly, you tell the court, if you do not give me this injunction order against this trespasser on my land, he'll keep trespassing on my land. He'll make my land a road, and people will continue accessing the places they want to access using my land. So when you tell that to the court, of course, you cannot be denied an order, an injunction order. Another remedy that you can obtain from court is what we call distress damage feasant. You have a right to detain the person who passes through your land or who trespasses over your land. You have the right to detain his animals, his property, if you're sure he does not have a good defense to it. So when you detain something, when you detain something that belongs to them, for them to leave your land, you're holding that something in a manner that we call distress damage feasant. So yeah, having cleared on trespass to land, if you have any questions, feel free to reach me. You know my contacts. Let us talk about trespass to person. Trespass to person takes 3 forms. Trespass to person takes the form of assault, battery, or false imprisonment. It occurs in 3 ways. When we talk about assault, battery, and false imprisonment, let's begin with assault. When somebody threatens to use force against you without lawful justification, that person, for example, points a gun to your head and he threatens to use that gun, then the person is assaulting you. Rules for assault: for there to be assault, you must have had a reasonable apprehension of that he was going to injure you. Secondly, there must be a means of carrying out the threat by the person who threatened you. So if he says, I will shoot you, and he has a gun in his hand, you can believe that he has a way of shooting me because he has a gun in his hand. Then thirdly, mere words without body movement do not constitute assault. For example, if I say I'm going to shoot you and that's it, that does not constitute assault. But if I hold a gun to your head and I say I am going to shoot you, then that is assault. So at least the person must have displayed force. He must have pointed the loaded gun or was threatening you in a manner that you had some fear. Yeah, so if you had reasonable cause to believe he was going to shoot you and you feared because you saw him act violently and you saw him put a gun on your head, or somehow he just had a means of carrying out his threat, then he has assaulted you. But battery is different. But when you talk about battery, it is the actual use of force towards another person. For example, when he actually hits you with a gun, they must have hit you very intentionally or very voluntarily, i.e. yeye ndio alichukua mkono yake akakugonga nayo. It is not enough if a person is convulsing, if a person has kifafa or that sickness, that epilepsy, and unfortunately they had a stick in their hand, and during the time of convulsing they hit you with a stick. They were not doing that voluntarily. It was not intentional, and therefore it cannot be battery. It cannot suffice to be called battery. Battery must have the 2 elements of intention and apprehension. Intention is where the person himself intended to hit you. You can tell from the look of things. He just came and he asked, where is he, and he came directly to you and he hit you. That shows intention. The person must not have been acting in self-defense. If you are fighting and the person hits you, that is not battery, because he was hitting you out of self-defense. Element number two to show when we're talking about the tort of trespass to person battery, apprehension. Suppose the plaintiff is an unusually fearful person. For example, people who are psychotic when it comes to fear, or they have paranoia. So the fear that comes with paranoia is not natural. It's not reasonable. That is a mental issue. But assuming the person who is reasonably mentally stable, perhaps sees you coming in, the person fears that you're going to beat them. That we call it reasonable fear. Apprehension is reasonable fear. Next thing we will learn is false imprisonment, where we talk about the tort of false imprisonment, the tort of trespass, and the element of false imprisonment. It occurs when the person is deprived of their freedom without any legal explanation. For example, if somebody takes you and keeps you in the house today without any reasonable justification, without your permission, then they have falsely imprisoned you. It's actually the act of imprisoning somebody, but in a false manner. What are the main ingredients for a tort of false imprisonment? Number one, knowledge of the plaintiff. The plaintiff or the complainant need not to know that they're being restrained. It just happens that if one day you are restrained, you can sue somebody for even if you knew or you didn't know. There's a case provided in the notes, Meeting versus Graham White Aviation. The person was being questioned at the defendant's company in connection to some thefts that were going on in the company. It was held that the person who held these people for questioning were guilty of false imprisonment. A person can be imprisoned without them knowing they are being imprisoned. They can wanaweza kuwa wameitwa tu for questioning, but they can that can amount to false imprisonment. I don't have to know I am being imprisoned for me to sue in false imprisonment. The imprisonment must be very intentional. The person who is holding me as their prison must have done so in a very intentional manner. There is a case in the case of Sayes versus Badwa. The plaintiff became imprisoned inside the defendant's toilet because of the door lock. It was not maintained enough, and the lock locked the person inside. Yeah, so but the court was of the opinion, if because of lack of maintenance the door locked you inside, then they cannot have been intending to. But it was the argument of the lawyer for the complainant that failure to maintain the doors, failure to act is acting to fail. And so, but the court was of the opinion that yes, it must be intentional. The person who imprisoned you there must be intentional, but that was a door lock. The door lock had an intention to lock you there, not the people who owned the building. So the people who owned the building were let go. Thirdly, the restraint. The people restraining you must have restrained you completely. I'm drawn to the case of Bad versus Jones. The defendant closed off the public footpath on one side of the bridge. The plaintiff was wishing to use the footpath, and he was prevented by the defendant. So the court was trying to ask itself, does this amount to false imprisonment? I mean, assume you're crossing from one end of the footbridge to another, and the other side has been closed off. You can always turn back. That was not complete imprisonment. What amounts to false imprisonment was, what would have amounted to was if they had closed the where he was going, and they had closed where he was returning to. So in that case, he would have been held as prisoner for some time. Then the court held in the court of Bad versus Jones that did not amount to false imprisonment. There are so many cases I have supplied you with in the notes. Please read on them. They're interesting ones, and you can use them to supplement your answers in the exam. So like we've said, the tort must be very intentional. Malice is not malice. We do not care for malice. So we don't care if you had good or bad intentions. The thing is, you locked somebody up for some time. You deprived them of their freedom totally. you must have confined the person either in a private house or in a common prison or somewhere. I just confined you. If I confined you to a place where you have not consented and I have no legal authority to confine you, then I have falsely imprisoned you. Defenses, how can you defend yourself? You can say, I had an authority. For example, I have authority to lock you up somewhere and teach you the law of tort for some hours. You can also say, I had a right to discipline or chastise my children as a parent, so I didn't falsely imprison them. I just told them, go take time off, think about what you have done and come back. So I can have parental authority or judicial authority. For example, as a judge, as a court of law, we can imprison you for some time if you make your own mistakes here and there. So yeah. And for a person who is claiming they have been falsely imprisoned, what are the remedies available to them? Remedy number 1, for all torts I have taught you, damages. You can claim for an award of damages. Number 2, what we call habeas corpus. Some of you may be familiar with this term, some of you may not be. The writ of habeas corpus is a remedy in this way. Habeas corpus means produce the body dead or alive. So if you have been falsely imprisoned, your family can go to the person who is imprisoning you falsely and tell them to produce your body dead or alive. Of course, they just don't go like that. They go to a court of law, they apply for an order of habeas corpus, the court gives them a document that they take it to the person, and the document reads in part, you are hereby ordered by this honorable court to produce the body of so and so, dead or alive, failure to which an action shall be instituted against you. And they're given a certain number of days, 3, 4, 5 or 7 days depending on the court, and they will release the person before the court. How would you use this? How is this beneficial to you? Sometimes the police officers may take you, arrest you, and constitutionally you have a right to be taken to court. If you are arrested today, you have a right to be presented in court within the next 24 hours for them to tell you why they have arrested you, and to tell the court why they have arrested you, and for the court to give you a bail and a bond if it is available. Now, sometimes the police may take you in, and I'm reminded of the case of Miguna. Sometimes the police take you in, they hold you in their holding cells, and they do not charge you. What are the remedies that are available to you? You can sue the police force for false imprisonment. If you sue the police force for false imprisonment, one of the orders that the court will give is an order for habeas corpus. Yes. Let's move very quickly to the tort of trespass against a person's goods or chattels. It takes, in the past it used to take 3 forms: detinue, conversion, and trespass to goods. But now, I would like us to learn detinue as another discipline. Detinue is holding somebody's goods or property. Goods, when I talk about goods, I talk about movable things like a car, necklace, earrings, phone, laptop. Yeah. So when you hold somebody's goods unlawfully, you're doing what we call detinue. You're doing something we call a detinue. Detinue is a discipline that is a bit different. I want us to tackle it in a different manner. Sometimes you're allowed to take somebody's property and hold it in lien. Something that let me just write it down for you. I don't know if you can see it. You can hold it as a lien. Is that clear? I don't know if that is clear enough. Lien. Sometimes you can hold somebody's property in lien. That means you're holding it as a security until they perform something that you want them to perform. For example, if you want to take a loan from somebody, they can tell you, give me your laptop, and I will give you the loan. Until you pay me the loan, I will hold on to the laptop. So detinue is unlawful. Unlike that of giving it as a security, somebody just takes your goods and they just detain it for no reason. Yeah. For you to sue for detinue, you must have asked them. So you must have demanded for the goods back. How do you prove to the court that you must have asked for your goods back? Normally, your lawyer will draft for you what we call a demand letter that demands for those goods. Yeah. So let's go to trespass to goods. That means you do something that is inconsistent with the owner's wishes to the goods. How do you do this? You take it out of, for example, if it was held by another person, I go and take it away. I have trespassed to those goods. If I move it, if my earring was left on top of my table and you take it and you move it to the other room, you have trespassed to my goods. If you touch it in any way, if I have not allowed you, you have trespassed against my chattel or my goods. If you direct a missile, it's a very big term, but it just means if you direct anything destructive to my goods and it actually destroys it, you have committed a trespass to my goods. It must be direct. I must be, if I'm complaining that you have trespassed against my goods, I must be in possession, not necessarily the owner, but at the time at which you are interfering with my ownership of that goods or of those chattels, I must have been in possession. Yeah. Defenses. I can defend myself by saying I didn't move the goods without the consent of the plaintiff. They had given me consent to move goods. If you had allowed me to move your property from room A to room B, then I can always defend myself saying you gave me the consent. Number 2, necessity. Necessity can be linked to what do we call it now? An act of God. You can say, because there was a storm coming, I needed to move this car out of this place. I needed to move this laptop because it was raining and the window was open and the window could not shut itself, and because the rain cannot be stopped, so technically I just moved the laptop because of necessity. And thirdly, you can always defend yourself by the good old defense. Mistake. I made a mistake. Yeah. There's so many more. Let me give you an assignment. Please read on the remedies when it comes to the tort of trespass to goods. Yeah. Let us talk about conversion just before we leave our goods. Let's talk about conversion. Conversion is a process by which you take goods that are originally mine and you convert them to become yours. Thieving, literally. You deal with goods you deal with goods in a manner that is seriously inconsistent with another person's right. For example, if I take the goods, or I dispose the goods, or I destroy the goods, or I alter the goods of without consent, or I just take them, I pick your pen and I make it mine, I have done the tort of conversion. Yeah. Defamation. Defamation, we are now done with the tort of trespass. We're done with trespass generally. We have talked about trespass to somebody's land, trespass to somebody's goods or chattels, and we have talked about trespass to a person, assault and battery. Now let us talk about defamation. This is a tort where I am famous for something, and the term defamation, just let me write it for you. Defamation. The tort of defamation, I hope you can see it, it's right there. You see the term defame. I am famous for something. I am famous for being a good girl. I am famous for being something. So everybody is famous for something. Now they have their own fame around a group of people. Then one time you come and take away that kind of fame, or you put the fame, you mar their fame. You have defamed them. So you have ideally said something that makes them appear as if they are not who they are. The tort of defamation is a tort against a person's reputation. Exactly. The tort of against a person's, everyone has a right to a reputation that they choose and that they want. Everybody, while you were growing up, every girl wanted to be identified as a virgin. If you tell people Mary is no longer a virgin, you're defaming Mary. Yeah. So the statement that has been made, if a statement is made, that statement must be one, false, So if I say Mary is no longer a virgin, yet Mary is no longer a virgin, then that is not defamation. I'm just stating facts. Secondly, the statement that I mentioned, Mary is no longer a virgin, must arouse some form of ridicule or contempt. For example, if I keep telling people Cyprian Nyakundi has HIV, people will fear to associate themselves with Cyprian Nyakundi. Or right now, using the example that is continuing right now, that so and so has coronavirus, and if it is true they have coronavirus, it cannot be defamation. So I must have been lying, telling people that so and so has corona. And secondly, it arouses some form of ridicule. People will stop trying to associate with you. And not just people who are rightful thinking, members of the society that think straight, members of the society that are rightful thinking. If they will think any less of you, then that will amount to defamation. The statement that I made about corona, now we are on our third element. The statement must have been in reference to the complainant. If I say Mary has corona, it has to be Mary who will complain and not Jane, who is her sister. Also, the statement that I made about Mary, I must have made it public. So just telling my sister is not enough. I must have made it so available to the public. I must have published it on some magazine, or even posted on Facebook, or did something that the public does not mean the whole of Kenya really, but it just means a large group of people heard me talk about Mary in such a way. So there are two kinds of defamation. Number one is libel, and number two is slander. When you talk about slander is the biblical example of Moshene. Slander is where I put it in a non-permanent form. That means I speak it. It left my mouth. It is not permanent. It can't stay in my mouth forever, but it just left my mouth, and people heard me. So maybe I said a statement that says Mary is a criminal, or Mary has a contagious disease like corona, or I imputed unchastity of a woman, where I said Mary is no longer a virgin, or where the statement itself, where I said Mary hizo pesa Mary konazo ni za corruption, all of them. So I imputed some form of image on Mary that is not true. So if I say it is slander. How can you tell? How can I help you to differentiate? Slander, say, S and S. Slander, say. When you say it, it is usually by word of mouth. But when I talk about libel on the other hand is when I put it into a permanent form. For example, I printed it in a magazine, or I documented it. You don't need to prove that if you are married, you don't need to prove that you suffered injury. You don't need to prove to the court the kind of injuries you suffered. But perhaps you can show the court that rightful thinking members of the society will think low of me because of what this person said. I have given a lot of resources in the notes. I expect you to go and read. Then occupiers liability. Away from defamation, the tort of defamation, I want to talk about occupiers liability. Occupiers liability is a law that occupiers liability is it stems mostly from equity. If I am occupying land as an owner or as a person in possession, there are some liabilities that I have as an occupier. What are expected of me? So at least one thing that is expected of me is a common duty of care. If you come to my land as my visitor, I have a duty of care to care for you. For example, the visitor, when they walk in, if there's a hole around my compound, I should notify them. And tell them, hey, there's a hole, you should watch out so that you don't fall into that ditch. Who is a visitor? A visitor can be a licensee. Licensee is a person who acquires a license from me to access my land, or an invitee, person who I have invited to come into my land. Can you be liable as an occupier of your land for persons other than your visitors? At common law, no. You're only liable for the people you allow to come into your land. So if a trespasser walks into your land and they did not know there's a I don't know if you guys know about booby traps. Booby traps are those ones that used to catch gazelles in the past. So somebody sets up a booby trap and the gazelle comes in, and they set a bait, the gazelle comes to get the bait, and all of a sudden the trap holds their leg or their feet up, and they're stuck there. The hunter comes back and takes away the gazelle. So if I have a booby trap in my compound and I have not invited anyone, legally speaking, and a person is busy trespassing on my land and they are hurt by a booby trap, I am not liable. They were trespassing for all I care. So yes, I want you to read more on the Occupiers Liability, page 117. Yeah, generally. That marks the end of our class of tort. So if we can just debrief for a moment. We learned about the tort of nuisance, the tort of negligence. Then we learned about the tort of trespass to land, to persons, and to chattels. Then we talked about the tort of defamation. And we talked about occupiers liability. I would like us to fit occupiers liability up there with tort of trespass to land. But we cannot, because trespass to land means a person coming to your land unlawfully. While this one is occupiers liability, it fits more of nuisance, not nuisance, negligence, and a bit of it fits into negligence because we talk about duty of care, the liability of a person who owns a land, who owns a land or who occupies a land. They have a duty of care. If they breach that duty, they're held liable. So it leans more into negligence than into trespass. Yeah. So I expect you to know the elements of each and every tort that we have learned so far, and if you can be able to tell me the differences between each, and the elements, the differences, and the remedies for each. Yes. So that marks the end of our class on tort. I would appreciate if anyone of you has a question, you can reach me. Feel free to reach me. I will answer, like I have always done. Till next time. Our next topic is the law of contract. Be prepared for that. I will use this avenue again because it doesn't look like our pandemic will clear anytime soon. So till next time, see you. Stay safe.